Hello. All. So a lot of people are concerned about the recent Supreme Court decision on in Trump v. U.S., which is it's the presidential immunity decision. You'll generally see people saying that it granted former President Trump immunity from prosecution, that it puts him above the law and things like that. And basically, this video is to explain what the decision actually states, because it does not just place the president above the law. It's more complicated. This is actually a fairly difficult case. The decision is over 100 pages, this is, and it's like I'm not even going to claim that I understand the decision fully. It is a very long decision, but I think I do have a pretty good understanding of at least the core concepts of this. And I want to explain kind of more what's going on and hopefully like decrease the panic, because it's like the Supreme Court issuing this when it issued this decision was in a very unenviable position. They were trying really hard to avoid a constitutional crisis. Um, and Mr. Trump has done a lot of things to make that very difficult. Even Nixon had the decency not to force a lot of the constitutional issues and legal issues that Mr. Trump is jumping headlong into. So the Supreme Court has, I'd say, the rule we'll see, I think, is actually pretty workable. But we're going to jump in and see why. But yeah, this was a very hard case. Very much do not envy the Supreme Court in having to write this or figure out how to handle it. There's virtually no precedent, legal precedent in this area, because again, virtually no one has made this an issue. Our prior presidents have been more responsible than even Nixon, than making this a problem for the American people, for the Supreme Court, etc. So, but yeah, we're going to break down the case and what it actually says. So the main thing we need to understand about the case is that it divides presidential activity into three different categories. And these three different categories determine what sort of immunity those actions are accorded. And we have these three buckets. The first bucket being the official acts that the president has exclusive and preclusive authority over. That's the language used, but basically it's like bucket one is the things that only the president can do. And I'm gonna jump into some examples in a moment. But this is a very narrow category. And this is the category for which the Supreme Court designated there would be absolute immunity from prosecution for acts within this bucket. Um, but yeah, it's things that only the president can do within the authority of within presidential authority. Then there's bucket two, all other official presidential acts. So basically anything the president does as president, acting as president, that doesn't fall into bucket one. Bucket two, rather than absolute immunity, has a presumption of immunity. And this presumption is rebuttable, like basically all legal presumptions. This is kind of comparable to, the presumption of innocence. When you're charged in a criminal trial, there is a presumption of innocence. But that presumption can be rebutted, and it's rebutted all the time. Every single successful prosecution rebuts the presumption of innocence. So the presumption of immunity basically says we presume the president can't be prosecuted for doing this, but you can convince us. Just give us a good reason. That's kind of basically what the presumption that's kind of what's happening in bucket two. Give us a good. It's like, we're not going to let you just waltz into court and say we get to prosecute this. You have to convince us that this should be open to prosecution. And this is largely and both bucket one and bucket two, there's this immunity concept, both the absolute immunity and presumption of immunity, basically to prevent a constitutional crisis and to preserve separation of powers, and because it's like you have each branch and each branch is co-equal. You can't have the judiciary improperly interfering in the affairs of the legislature and the executive. And there's actually other immunities that already exist. For instance, congressmen are, this is not going to be a fully correct statement of law, but roughly speaking, it's like congressmen they can't be they have absolute immunity for comments they make during, on the Senate or the House floor. So you can't like sue them for defamation for something that they said while testifying, while they were speaking on the Senate floor or the House floor, because that would mess up, that would cause a lot of that could open up the door for a lot of judicial interference in the legislature's proper operation. And we don't really want to do that. We want people to be able, we want each branch to be able to do its job without the other branches interfering improperly, or without each branch getting co-opted by political interests to prevent each branch from doing its job properly. And that's already a big issue in our government right now. So we really don't want it to get worse. So that's kind of the motivation for these immunities. And there's also, of course, things like sovereign immunity, which is an even bigger topic, and an even more sweeping immunity. But I'll leave that one at that. That's too big a concept to get into right now, and it's not quite exactly the same. But yeah, then we get to bucket 3, which is unofficial acts, because the president is a person, and if the person who holds the office of president does something that is not inside, that isn't pursuant to a presidential power or anything, then that is just not it's not a presidential act. It's like when he reads the newspaper, when, like, I don't know, when he talks with the neighbors. I guess you don't really have nightmares anymore when you're in the White House, but if they hop back to their old family home or whatever, or like actually like a lot of things. We're going to get into some real examples here, because of the examples matter. But we're going to jump back to bucket 1. Just because it's basically like bucket 1 is the small one, bucket 2 is pretty big, and bucket 3 is very big. So they're kind of defined. Each bucket is defined in not being the other ones. So it's like bucket 2 is defined by not things that don't fit into bucket 1, and bucket 3 is things that don't fit into bucket 1 or 2. So that's kind of how these buckets are defined, or these categories. So bucket 1, again, these are official acts that only the president can do. So these are things that Congress cannot do. These are things that the judiciary cannot do, that no other part of the government can do. The decision actually doesn't spend, at least the parts I've read, don't go a ton into detail in terms of examples on this. But that's also because this bucket 1 is pretty small. Generally speaking, there aren't a ton of things that only the president can do. And this is also probably the hardest part of the decision, is knowing exactly what fits into the buckets 1 through 3. And this is, we'll get into this, the court doesn't answer a lot of the questions here. It just, because its job here is just setting up the rules, and it would have actually been a bit premature to decide some of the questions here. So, but yeah, so official acts that only the president can do, like off the top of my head, I would think that would probably include things like the commander-in-chief functions of the president. So yeah, because it's like the Congress cannot replace the president, that in terms of performing commander-in-chief functions, the judiciary can't. The one concrete example, from what I understood from the decision, is when the president is involved in making decisions of prosecutorial discretion. The court discusses Trump allegations about Trump using his influence to request certain prosecutions of political opponents from the Department of Justice. So the thing with prosecutorial discretion is that prosecutorial discretion is always highly protected, not just, so it's like, it's like, I don't love this being in bucket 1, but it is in bucket 1. It makes sense why it's in bucket 1, and it's pretty consistent with the rest of our law. Prosecutors already enjoy quite a lot of prosecutorial protection for their prosecutorial discretion. And we'll get into some reasons why, because it's like, it's actually pretty hard to do bad things with abuse of prosecutorial discretion, because you'll usually run into different like you'll run into problems with non-criminal laws. And but yeah, bucket 1, it's like, it is pretty small. I am pretty confident in that. The edge between bucket 1 and bucket 2 isn't clear, and the court notes that to some degree. It is kind of hard to tell. And I'm calling them buckets, but if you want to think of them as kind of more of a spectrum, I think that's, in some cases, for some issues, that's going to be a bit more accurate. But yeah, so after bucket one, we have bucket two. And bucket two is going to be most things that the president does while acting as president. So like acting pursuant to congressional authority, that stuff is that's not exclusive authority of the president. It's like when Congress delegates authority to the president to make certain decisions and things like that. Generally speaking, things like that, that's probably going to fall into bucket two. Um, and a reminder, bucket two is going to have that rebuttable presumption of immunity. Um, Beyond that, the court specifically mentions addressing the people in a presidential capacity would fall into bucket two. And that's kind of, and this act addressing the people in a presidential capacity, this is actually one of the ones that kind of causes a problem in the present case. And then working with the vice president and the vice president's role as president of the Senate, that's another one that the court seems to indicate is in bucket two, if I understood it correctly. Then in bucket three, we have unofficial acts, so anything not done within the office of president. Interestingly enough, and this is the court specifically identifies that when the president is acting as a political candidate, when he's campaigning, when he's giving a speech, and I'm using he because it's Trump. Trump's at issue, but when Trump is campaigning, when he's speaking, or when he was acting as the president of the Republican Party, just because he was also holding the office of president at the same time doesn't mean those were official acts. So it's like when he was anything he did as head of the Republican Party or anything he did as a political candidate would be in bucket three. And you can kind of see where like addressing the people in a presidential capacity and political campaigning, there's the line there is pretty fuzzy, and we're going to talk a bit about that in later, but yeah, these buckets aren't necessarily like fully fleshed out, and that's, I think, a large consequence of the fact that this stuff hasn't been litigated in the past. This is all new stuff, hard to figure out stuff. And it's hard to know exactly how this is going. Some of these decisions are going to flesh out, and part of that's intentional, for something we'll get to at the end. But so I'm going to explain why I think this rule makes sense, why these three buckets do, like, I don't know if it's what I would have come up with, but it's like, it's workable. And here's why. You kind of have this sliding scale of where from bucket one to bucket three. Bucket one is stuff that nobody else can do it. So if we interfere with the president being able to do it, that causes problems. Like, because if we don't let the president do something, nobody else can do it. So if it's necessary or things like that, they're like bucket one is duties we don't want to interfere with, because if they need to happen, they need to happen, and we don't want to provide a lot of levers for like opponents of an unpopular action or a popular, like we don't want to give people levers to prevent the president from doing what's necessary, or what only the president can do, even if it's not necessary, like strict necessity. That's a political issue. But beyond that, there's, I think, some like practical wisdom here, because going down from bucket one to bucket three, bucket one is going to be the stuff that where, like, my sense is that like the prosecution, any prosecution for acts in bucket one are much more likely to be attacked, and fairly attacked in some cases, as being political attacks, and they're much more likely to cause a constitutional crisis if you prosecute them. And that kind of, and the sense of that kind of just decreases as you move away from bucket one. So it's like by the time you get to bucket three, it's like people will still attack any prosecution of bucket 3X as being political, but the attacks are a lot less likely to be fair. And then like bucket 3X, you're not going to cause a constitutional crisis by prosecuting bucket 3X. Bucket two, some acts are going to have these problems, some acts aren't, and that's why that's why there's a rebuttable presumption. A rebuttable presumption leaves you room to argue, and say it's like, and I think these are kind of like some of the concerns that you'd want to argue. And just to be clear, this isn't legal advice if anyone is planning somehow to rely on this information. The only people who could, I imagine, could possibly rely on this information as for legal strategy would be Mr. Biden or like Mr. Trump. But it's like if you're Biden's or Trump's legal teams, go do your own work and don't get your information from YouTube. That's my recommendation to y'all. And that is still my recommendation. It's like if somehow anything I say regarding with respect to the law is personally relevant to you at any point and in any way, go hire an attorney. Don't rely on YouTube ever for legal information. And that includes me. It's like, if you really want to understand this decision, go read it. I'm providing this because people don't have don't have time to read a 100-page decision, and they don't have most people don't have law degrees. And this is a hard decision, even if you do have a law degree. It's not necessarily easy. Anyway, sorry for that. Necessary legalese, whatever. But yeah, so from bucket 1 to bucket 3, and the other thing is that like bucket 1, we're also talking about like the scope of activity covered. Bucket 1 is the narrowest, and by the time you get to bucket 3 is just way bigger, covers way more conduct, way more things. So yeah. Oh, one note I did forget earlier was that the court did state, this was a phrase I was confused on, so I dug into it a little bit, because it's like people were saying you couldn't look into the president's motive. And there is language in the decision that discusses like you can't look into the president's motive. From what I understand of the decision says that you cannot look into the president's motive for purposes of determining whether something is in buckets 1, 2, or 3. So you can look into the president's motive for other purposes. But it's like the motive isn't going to be what decides that something is in bucket 1 or bucket 2 or bucket 3. So it's like if something is in bucket 1, an improper motive isn't going to take it out of bucket 1. If it's in bucket 2, an improper motive isn't going to take it out of bucket 2. Basically, it says it's like when we decide whether something is in bucket 1, bucket 2, or bucket 3, we're doing that based on the actions and the conduct that we can readily identify. We're not going to do an inquiry into the motive to determine whether something's in bucket 1, 2, or 3. So it's like, it's not saying that motive is irrelevant or that it can't be used by a prosecution of a president, but it cannot be used to decide whether something is in buckets 1, 2, or 3. That was a fairly hard thing. That was a more complicated part of the decision, but I think that is an accurate description of that. Of what's going, and I should have mentioned that. I was going to mention that earlier, but slipped my mind. And I thought I should mention that. Anyway, so this is the other practical reason why I think this rule is pretty workable, like this bucket approach. Because reality is a machine that turns crimes into evidence. Which is a weird way to say it's just like perfect crimes tend to not work. And like crimes just produce evidence in the commission. It'd be really, 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 really hard to commit a genuine crime using solely bucket 1 conduct. Even using solely bucket 2 conduct, it's pretty hard. Generally speaking, it's like parts of the commission of the crime are going to involve conduct that falls squarely outside of bucket 1. And probably bucket 2 as well. And typically speaking, it's like strictly bucket 1, bucket 2 conduct it's going to be hard to criminalize anyway, because it's governmental functions. And additional to the fact that like a prosecution is typically going to have more evidence than just what falls into buckets 1 and 2. And if it only has evidence, like if the entire evidence of the criminal behavior falls into buckets 1 and 2, it's probably not going to be a strong prosecution case in the first place. It may be very difficult to convince a jury. You're not going to have a strong, it's kind of just a pragmatic consideration of like, it may not make a big difference, is it kind of the thing. It's like, it almost like shifts or sifts like the quality of evidence. Or like how useful the evidence is actually going to be. Because like bucket 1 and bucket 2 conduct, there's a good chance it wouldn't be useful for the prosecution, or if the prosecution had to rely on it, then the case may not be strong in the first place. Because when you're a prosecutor, you always have to be considering, can I convince a jury beyond a reasonable doubt of guilt? And it's if the entire evidence is composed of bucket 1 and bucket 2 conduct, which are very public action, which are mostly public action. Some of them aren't public, but it's like things that are very narrow in scope or very public or things like that. It seems pretty unlikely that a genuine crime is not going to produce evidence in bucket 3 or evidence in bucket 2 that can be reached over the presumption. And then the other practical consideration to remember is that for improper presidential conduct, there are still plenty of other safeguards besides criminal law. This is just with respect to criminal prosecution. So if the president is doing something improper that fits into bucket 1 or bucket 2, even if it's not criminal, there's a really good chance it's going to be unconstitutional in the first place. And if it's unconstitutional, it's probably going to get interrupted before it can even get completed. So for example, like I mentioned that prosecutorial discretion has been identified, a form of prosecutorial discretion has been identified as being in bucket 1. If the president were, say, to like issue a bunch of racially discriminatory spurious prosecutions, it may not be criminal for the president to do so, but it's like if there's like adequate evidence, like it would certainly be unconstitutional. It would like those prosecutions would violate the 14th Amendment guarantee of equal protection or things like that. If the president is using false evidence to prosecute someone, like then there is a crime. There are protections against perjury and false evidence, presenting false evidence to a court. That can be criminal conduct on its own that would fall outside of buckets 1 or 2. So it's like there are other protections to keep the president in line besides criminal law. And so it's like this, like a criminal prosecution of a former president is kind of like we really don't want to have to get there, which thanks Mr. Trump for bringing us here. But yeah, our government tends to have that's the reason why, like, despite how mad all of our politics are, like things haven't fallen to pieces yet. It's because we have genuinely really strong systems that prevent, to a large degree, shenanigans. And that's what's going on here. So it's like, even if the president can't be hit with a criminal law, like a lot of improper presidential conduct is usually going to violate some constitutional provision and get cut off at that stage. And if we talk about, like, if the president murdered someone, that would be bucket 3. Killing people is not an official act of the presidency. That's just something people decide to do. So yeah, like the point is like, from a practical standpoint, the president is still heavily constrained in terms, like there are still lots of protections in terms of what the president is able to do. And that's going to continue to be the case. The Supreme Court, like despite what people claim, like the Supreme Court has been more than willing to check presidential power over the past presidencies. And it's like Trump lost more, like, if I recall correctly, I may be wrong on this, but it's like, if I recall correctly, Trump lost more cases before the Supreme Court than any other president. And that was even when he had the judges he appointed, like Gorsuch and Barrett and Kavanaugh. It's like they've been more than willing to rule against him and have ruled against him on several occasions, in some cases on highly contentious issues. And even in this decision, they make it clear that the position advanced by Trump is not accurate. They make it very clear that they do not accept Trump's legal team's arguments in the decision, and that what Trump was claiming was a complete overreach, because Trump was basically claiming complete immunity. And that's almost why I want to emphasize this, is it's like Trump is the one who is claiming that he had complete immunity, and the court said no. So it's like when we say that the court said yes, that Trump does have absolute immunity, that's just kind of like, that's doing Trump a favor, you know? It's doing Trump a favor to say that the court agreed with him, because the court didn't. So what's next? The first thing so this is kind of a legal procedure thing, but the court did what's called a remand. So they issued their ruling, which set up this rule that I described, and then they returned the issue to the lower court, the District Court of the District of Columbia, if I recall correctly, the Federal District Court of DC, and basically directed the lower court to basically make decisions on certain factual issues and certain legal issues as well. And that makes sense because the parties, both the prosecution and the defense, they didn't know this rule existed because it didn't exist when they first argued the case. So basically, by remanding it, it gives the prosecution and the defense time to modify their claims and their arguments and things like that and make it reflect the new rule. So that's basically what's going to happen next. We don't really know what this rule does until the lower courts apply it. And that's true of all good judicial rules. Like the Supreme Court will issue a rule, and we won't really know what the rule means until lower courts start applying it, because the meaning of a rule ultimately comes from its application rather than the words that compose it. And even when you have like the best judicial rule in the world, it can be ruined by bad application. And even like mediocre judicial rules can be saved by good application or prudent application. So ultimately, what's more important in this case is really how the district court chooses to handle things. And it's already started work on that, I believe. I think I saw that. But really, the big issue is what does the big issue with this present case is ultimately going to be what the district court decides to do with things. And whatever the district court decides to do, there's a good chance that'll get appealed anyway, and that'll get taken up by the Court of Appeals, and then maybe it'll end up in the Supreme Court again, and we'll get another Trump v. U.S. in like in a year or two. I don't know how fast this case might actually go faster than that because it is a pretty urgent issue. But yeah, some of the issues like I mentioned, so like some of the things that like the district court is going to decide is political. So like when like all of the statements that Trump made and at various stages and were part of the prosecution's case, the district court is to decide whether it falls into bucket 2 or bucket 3. Was the president addressing the people? Was he acting as a political candidate, and things like that? So that's like what so that's what some of the arguments are going to be. That's what some of the factual presentations are going to be, things like that. Determining and arguing, the prosecution, the defense, each side arguing for like that this specific conduct is falling in bucket 2 or bucket 3, and then after that it's like if it falls into bucket 2, can we rebut the presumption, and trying to convince the judge that the presumption can be rebutted, things like that. But yeah, this is a very new area of law, so it's really hard to predict. I'm not going to attempt to predict what happens, but hopefully the district court does a good thing. Hopefully it does good things, and is prudent and wise and etc. And hopefully we don't have more and more reason to develop this area of law. It's not really clear how this rule would interact if things keep getting pushed. If we do start running into constitutional crises anyway, or if like even worse presidential conduct comes to light, or things like that. So it's like this rule isn't necessary. Like this, it's like it is important because this is such a fresh area of law that like with so little litigation, it's like the rule that gets handed down isn't necessarily going to be like concrete or as stable as you might get in another decision. Things can get much more complex than this, and things can keep developing. So we'll see. No one knows what the future holds. Not Mr. Trump, not Mr. Biden, not the Supreme Court. So if things change, then things will change. That's the way of the world, and that's the way of the courts as well. So yeah, and I would just like to make my own personal legal theory is it's like my kind of hope is that like we have these 3 buckets. As I mentioned, it's like because there's a lot of blurriness between like the buckets. My hope is that when something is near the line, especially between the line, like something is like not clearly bucket 2 or bucket 3. Like for instance, political, whether like deciding whether a statement is bucket 2 because it's addressing the people as in the office of president, or whether it's bucket 3 because it was a part of a political campaign. It's like if something ends up on the line, my hope is that they'll take the courts will gradually take an approach that that for edge cases that it's not going the decision about which bucket it's in isn't going to matter as much, because like my intuition, or like this is what I would argue at least, is that like if something is on the line between buckets 2 and 3, then it should be a lot easier to rebut that presumption. Rebut the presumption that bucket 2 enjoys. So like even if it falls into, like even if conduct that's on the line between 2 and 3 falls into 2, because it was so close to 3, my intuition would be that it would be a lot easier to rebut the presumption, because the rationale for protecting bucket 2 conduct is going to be a lot weaker for conduct that is only barely inside bucket 2, and is almost in bucket 3. And that's so it's like that. So in a lot of ways, it's like noting that and noting things I've noted before. My hope is that like this decision ends up not being that consequential, so to speak. Like it matters obviously, but like I certainly don't think it's automatically this catastrophic thing that grants the executive like immunity from the law. It does not grant the president like immunity from law. It's still very much like the president very much still can be prosecuted. Everything in bucket 3 is still fully prosecutable. And even things that are in buckets 1 and 2, like bucket 1's prosecutable, I mean, not prosecutable, it enjoys immunity. But even though it enjoys immunity, it's like, it's still going, it's like, it's going to cast smoke. If you try to commit a crime through bucket 1 conduct, you're going to make smoke. It's like where there's fire, there's smoke. It's, it's really, really hard to make things invisible. Especially like few people have more eyes on them than the president of the United States, if anyone. So it's like, like my sense of things is it's like this is a significant decision, but it is a workable rule. And if for later decisions continue to like be prudent and careful, and then I think we can get good results out of this rule, and things can be okay. And things being okay is what we really want at the end of the day, isn't it? So yeah, and hopefully this can just help you not worry so much for those who are worrying, because it's like this is, as I've mentioned, it's a complicated case, and it would be hard to understand, especially like it's not easy to understand even with a degree in law. So it's like if you're a layman, then it's like it's totally understandable that you wouldn't understand what's going on. But there is also a lot of rhetoric that like there's very alarmist rhetoric surrounding the Supreme Court right now, and certain politicians and pundits have been have irresponsibly contributed to that. And it's like part of this is like the Supreme Court is a very academic institution. It's a bunch of lawyers speaking to lawyers and all that jazz, and it's not very accessible. And that's really like the alarmists have exploited that to try to force the court to respond to political pressures. And really, like, the court is one of the few institutions in our government that is fairly successfully resisting most political pressures. It's like it is by far the least political branch of the three, and I really don't want to lose that. And I don't want the Supreme Court I don't want people to think the Supreme Court has a character that it doesn't possess. There's plenty of places where it's like I'm happy to criticize specific decisions and things like that. And it's like this decision isn't like, I don't think I would have written it. It's like it's not necessarily how I would have just framed things. I've already discussed some ways where it's like I think it's like there's some ambiguity I don't like and things like that, but it's like I can respect it. I can respect this decision, and I can understand where it's coming from when I dig into it, even if like the initial sound of it is like absolute immunity for a category presidential election. That sounds bad. It's like, and it does sound bad. But it's also like it's not as bad. It makes sense when you dig into it, and it's like even if it's not the best approach, even if we have to modify it down the line, it's not like the Supreme Court is like trying to destroy the country or like establish like a fascist state or anything like that. Or like, I don't know, all the crazy things you hear. Basically, this little last bit has been, don't stress as much about the Supreme Court. They're not insane. They're all academics. They're all very educated, very intelligent people. And it's like what they say is respectable, even if you disagree with it, if you really understand what's going on and the reasoning and things like that. And it's like, I don't think I've read a single Supreme Court, like, like in the history of there are like maybe on like two hands, like less than 10 decisions where I loathe. Okay, maybe more. I don't know. That's getting into different. Basically, like don't like the Supreme Court is trying its best. Okay, and it's like they're doing it better. It's like I'll take them over the legislature or the executive any day of the week. That's the real takeaway. So that's it. What I have for y'all. Hopefully, it's like I know this took 35 minutes, but like considering this was a over 100-page document, and it's like this is involving a lot of complicated things. Hopefully, this is an adequate summary or introduction. If you do really want to understand it for some reason, do go read it. Read it yourself. If you don't have legal training, it may be difficult, and you may misunderstand a lot of things just because something. This is something important to note about the law. Just because you read something, you can't. When you're reading legal text, you often cannot trust your own understanding and trust your interpretation. A lot of words turn out to be like terms of art or have a lot of history behind them, a lot of baggage. And if you're not legally trained, you may not pick up on that baggage and completely read things completely wrong. So just be aware of that if you do choose to read the decision yourself. And yeah, that's where we're at. Take care. See y'all on the flip side, and just, be safe. Be safe. Take care of each other. And au revoir.